We are here now, and now I've lost track of everything. State versus Conley, and the appellant has around 4 minutes left.
May it please the court, I apologize for being late, and I will not insult the court by attempting to throw my entire argument into the last 4 minutes. If the court has any questions, I'm certainly willing to answer them. However, the basis of the argument is obviously on the 8th Amendment, equal protection and due process. The Ohio Supreme Court recently came down with a decision in State versus Blankenship that spoke to the issue of the 8th Amendment. I would point out that State versus Blankenship did involve a minor and wasn't involving a felony. In my case, my client is involved in it's a 3rd-degree misdemeanor as well as an adult victim. If there are no questions, I cannot apologize enough.
No. Things happen. It's fine, and we'll just hear from the other. Did you want to say any? You can. I'm going to allow you to say if you don't want to say anything about time.
I had a baby 6 weeks ago. I really apologize.
You had what?
A baby. We're just working through some kinks.
It's perfectly fine. We understand, and everybody up here has had issues in the past, so we understand, and obviously we'll consider the briefs. But I am going to obviously give you a chance to present your arguments to the court.
Your Honor, Nicole Welsh on behalf of the State of Ohio, City of Stowe. I had a brief moment to speak with Sarah before I stepped up here. Had I known she was going to make any arguments, I would not have wasted the court's 15 minutes because
Nobody's ever wasting her time.
My discussions or arguments here in front of you would have been based on what she had to offer outside of our briefs. Mm-hmm. There are 3 capable women who I'm sure read our briefs at length. There isn't much more for me to add to the argument. I would like to suggest that when she filed this brief, she mentioned Blankenship in her footnotes, which is what triggered me watching the decision. And the decision came down before I had to enter my brief into the court's clerk's office. So I was able to include that and incorporate that into my argument originally. But one thing that stuck out to me in recent weeks in re-looking at the Blankenship case for coming in here is the fact that Mr. Conley would essentially be making the same argument Blankenship made, that he wants there to be a categorical prohibition for Tier 1 offenders as it relates to him. He is a first-time offender. He does have a low risk of recidivism based on the information provided to us at the trial court level, and that his psych profile wouldn't have any characteristics of what we usually see in sex offenders. But the court in Blankenship said that reliance on any argument or basis is misplaced, that the state statutory scheme provides for automatic consequences, and that no judge has the discretion to modify those consequences. And in order for that new categorical rule to be adopted, the U.S. Supreme Court would have to consider 2 things. And they couldn't find it in the Blankenship case. We should certainly not find it here in the Conley case. This entire appeal is based off of legislation that was passed that requires them to register as sex offenders and report during a certain number of years so frequently.
And the purpose of that is obviously really to protect the community, right?
Yes, Your Honor. Actually, that's where I was kind of going with this. If the legislature has the constitutional power to enact the law, no matter what the law, whether the law be wise or otherwise, is no concern for the court.
It's not concerned for the court, it's just the constitutionality.
Right. But these laws were actually enacted for the protection of the public. We need to know.
How do you differentiate who's the one that you really need to watch out for? If everybody's labeled the same way.
But they're not all labeled the same way. That's why there's
Tier 1.
That's why there's categories, though. But, I mean, the more serious the offense, the longer the lengthy term. When you talk
get on the website, I'm just curious. If you get on the website, how is that differentiated?
I don't know, because I haven't been on the website.
Okay.
Being honest, yeah. I mean, I don't go and look on that. But when I think about it, yeah, he's a first-time offender, but so was Blankenship, and so could anybody else. Who walks into this?
No, I was just wondering about the category, like you said.
Yeah, I mean, we have a Tier 1 is 15 years. It's the least amount required. Some of the other things that I had highlighted in my brief to discuss was basically the fact that, you know, some of the things that he brought up aren't necessarily things that he's facing right now. You know, like moving within a school zone, or having to do any number of other things. But I go back to Blankenship because it's so recent, and it's really on target, and it really parallels our case today that's before you.
It seems like the constitutional argument is not about, I mean, the response is that this is to protect the public, but the constitutional argument is about the punitive nature as it relates to the defendant of the requirement, which is different than saying this is why this law is out there.
Right, and I do have some notes on that if you give me a second to find that. I made some notes in my time waiting about the difference. Ohio still looks at it as punitive, and my suggestion to the court would be that in 2011, the Ohio court found in Williams that it to be punitive in nature, and that's how we've held it here in Ohio since that time. However, in 2013, the United States Supreme Court described the federal sex offender registration law as establishing a civil registration requirement that is eminently reasonable, and that's United States versus App.No, if I'm pronouncing that right. And so they suggest that it should be civil, and then that it's eminently reasonable for that reason. And actually in the Blankenship decision, the dissent, O'Connell, made those same arguments. He said that we should be going based off of our old court precedent as well as the finding in that case, that this should actually be a civil penalty and not part of the punitive or the sentencing structure. And his dissent's pretty extensive. But I found it interesting that that was something that he wanted to notate.
And Blankenship was speaking to which constitutional element again? Was it?
Cruel and unusual punishment is what they targeted. They had originally, I believe, started out talking about more, but their whole decision was focused on the cruel and unusual punishment. When I went through my brief and I looked at it, you know, from a historical standpoint, in '94 we had Megan's laws, and they allowed for those hearings that the defendants still want today to say, hey, look at me as an individual. And they found that that whole procedure was wrought with too much opportunity for a defendant with a smooth-talking attorney to talk his way out of something that he should have otherwise had to do. So in 2006, with the adoption of the Adam Walsh Act, they did away with that, and they created the tiered structure to address the concerns that not all defendants were created equal. So I would, you know, refer to just history and where we've come from to where we are now.
And I think I'm recalling that your brief implies if you plead to the offense knowing that there's a registration requirement and what that is, there's an issue there with respect to later making constitutional arguments, or no?
You know, obviously he knew the extent of it. The trial court judge did go over that form with him and his counsel, did tell him the term of which he would have to register with, how often, and, you know, gave them the information as to where they would have to go to present. So he did raise, there was a small argument in the trial court where he raised these same three arguments, but the trial court judge restricted our arguments at that time. Hold on, let me see my note. I just want to make sure I don't misspeak. Judge Hoover had decided that the due process and equal protection claims had been decided by other courts previously, and as those cases had not been overturned, we would have no need to discuss those. And he actually encouraged us both to brief out the cruel and unusual punishment part, and so that's what we had the hearing on in the trial court. And with the Blankenship decision, that argument kind of goes by the wayside. The court doesn't have any more questions.
Thank you.
You're welcome.
Thank you to both sides. The court will consider the matter and take it under advisement and issue a written opinion that will be sent to both sides, as well as you can check on our website and as well as the Supreme Court website. We have many places that you can find out information, so thank you so much.
Thank you so much, Ron. Thank you.